So, hello, Channing. My name is Alejandra. We would like to thank you, first of all, for your time to do this interview with us. All of us, all team members from Legal Help Advisor, are really appreciate this, and we know this will be quite rewarding and helpful for us. Our main goal is to educate more people in regards to this difficult and delicate case, as well as to provide victims of sexual assault with relevant and trustworthy information. So I'm going to start with a few questions. To begin with this interview, could you please tell us a little bit more about yourself and your experience?
Yeah, so I am an associate attorney at Pitt McGee Palmer Bonani and Rivers. We are a plaintiff's firm in Royal Oak, Michigan, and we um, focus on civil rights and employment law, representing individuals who have been harmed either by the state or their employer, a municipality, or some kind of other state actor. And that can be any kind of form of discrimination, harassment, any kind of unlawful basis for termination or a violation of their civil rights.
I see. As you mentioned, you're currently working in so many different cases, but is there any particular case that you've been working on that you consider meaningful or remarkable? Could you please tell us about your experience working on that case?
Yeah, so I'm lucky to have a number of cases that I think have been very meaningful. I play a role on the Flint water crisis litigation that's been ongoing for 7 years, and we've had the settlement with the state of Michigan and on behalf of the class that we represent and our individual clients. That's been incredibly meaningful. I recently resolved a case for a young woman who was sexually harassed and assaulted during just a 1 week of employment. And it was just a really egregious situation where her supervisor was held this position that he was able to assert so much control over her in his supervisory role, and she was just an 18-year-old woman in her first job, and really vulnerable. And he was daily harassing her, which culminated in an assault. And so work like that we're able to find a resolution for our clients to get them some kind of compensation for the harm that they suffered, because that's frankly what the law allows us to do, is to get compensation for those survivors, and then to hopefully help her on the road to recovery from that and closure.
So that's an incredible job you guys are doing. We understood, as it was said in the MTMP, that most women victims, they don't even know what they have been through was actually sexual assault. So could you please explain what sexual assault is?
So sexual assault is any kind of unwanted sexual touching. So that can be, and I don't in any way mean to minimize, any sexual assault is wrong. It's unwanted, it is offensive, but it could be as simple and brief as groping, and it could go all the way to the other end of the spectrum as rape. So it really can be any kind of unwanted sexual touching. That would include assault, and that would then also correlate with our criminal code in Michigan and be assault and battery as well, and potentially a number of other crimes if it includes rape.
Now, it must be difficult for sexual assault victims to discuss the details in depth of what happened to them. So, what are the difficulties that you as a lawyer encounter the most when you're trying to connect with the victim?
Well, so first is the first real step to getting a client to open up about their experience is connecting with them and creating a safe space. Um, what's critical is making sure that the client knows that they're in control. Um, Control is taken away from a person when they are assaulted or raped, they lose that control. And so providing a space where a survivor takes back that control and has control over their story is key. And I don't think that a lawyer can properly represent their client if they don't first create the space for that to happen. Um, so, in giving the client, you know, creating the space for them to take back their control, um, they hopefully begin to trust the attorney. They're free to tell their story in the way that they're comfortable with, and that might be very fragmented. It might be, not a linear narrative. It might be jumping all over, but it's about being patient and again, just making sure that we give them the space to take that control and tell their story in a way that they're comfortable with. And it might take a number of conversations to do that. But it's about whatever it takes to get them there to the end.
Thank you for this valuable information. Now, for this particular lawsuit, is there a statute of limitations that they have to fit within regarding the state that they lived at, or it it doesn't really matter the statute of limitation?
Statute of limitations is always something that has to be considered in a lawsuit. And a claim of sex harassment or assault is no different. It will go by the state that you live in, and it will depend on the context that you are bringing the type of claim. So, for example, a client who is alleging sex harassment against their employer in Michigan will have a 3-year statute of limitations under the state's Elliott Larson Civil Rights Act. If they are alleging a tort against the individual of assault and battery, there will be a different statute of limitations that applies in Michigan. And there's a whole different statute of limitations that applies if the individual is asserting a claim against the state or a state actor, because in Michigan, we have a Court of Claims Act, which requires that we provide notice to the Court of Claims of any claim that has accrued that we plan to bring. And you have to do that within a shorter time frame than you would if it was a private employer or a private actor. So it's something that you have to be aware of. But on the positive end of statute of limitations, there's a lot happening to extend statutes of limitations in states. I know in Michigan, a bill was just presented in the House, the state House, to extend the statute of limitations for survivors because it's becoming accepted that survivors may not bring a claim right away. Their brain needs time to process what's happened. They may just not want to pursue something right away. And so allowing survivors more time to process and make important decisions about what they want to do and not punish them for not moving really quickly is really driving this effort to extend the statute of limitations for them.
And what happens to them? They lose the opportunity to file a claim.
Yes, if you do not bring a claim within the statute of limitations, you would be prohibited from doing that. And so again, to extend that is really critical for survivors. So for example, we learned in the Anderson case, which was against the University of Michigan, that these men now are 50s, 60s, and they had never disclosed what had happened to them in most cases. So, we're looking at decades after an assault, and these gentlemen are just now able to say what happened to them. And it would really be a shame for them to be prohibited from bringing those claims. It seems a punishment to them. And really, it's what really the law should be providing is an outlet for justice. So allowing these survivors to bring their claims when they're more comfortable doing so really just seems the right thing to do.
And just one more question. In your experience, which state deals with this type of cases the most?
I really don't know the answer to that. I think that would take a lot of data that I just don't know is available. I would assume that everyone has their fair share to go around, just like other areas of discrimination or violations of civil rights. I think that we see that everywhere, and you have bad actors all over the country, and we all just have to do our best to root it out and fight those causes.
Thank you so much, Channing, for your time. We really appreciate it. And I hope we can speak again soon. All right.
Yeah, thank you so much.